Welcome once again to the Waterstone Legal Update, and today I'm joined with Adam Botterill, and we are going to be talking about the PopUp Globe Foundation, but more importantly we're going to be talking about the 10-day rule. So just a bit of a background. In the raft of legislative changes that came in last September, one of the changes was the 10-day rule was, we thought, abolished. And that 10-day rule is once a debtor company has been served with a liquidation application, they had 10 working days to appoint their own liquidator. The new rule came in, and what was the perception of the legal and insolvency community after that rule came in?
Thanks, Damien. Well, the perception was pretty clear, and I even did a short video about the changes and the fact that the 10-day rule no longer applied, that shareholders didn't have this grace period, as you would put it, to essentially appoint their own liquidator. The industry thought that in this time period, you could only appoint a shareholder liquidator with the consent of the petition creditor, or the one that had applied to liquidate the company. And there were a raft of law firms and insolvency firms that actually thought that was the case.
Including us.
Including us. We have here Chapman Tripp in 2019 put out an update about voluntary appointment of liquidators, and they said that they only had until 10 working days to liquidate under the new law, and appointment after that period would be possible with the consent from the applicant creditor. So that's Chapman Tripp 2019. We have Kensington Swan, really good firm, January 2021. Here they also put out an update. They said that the creditor's rights had been strengthened by a prohibition on voluntary appointment of liquidators after the service of liquidation proceedings.
Yep.
Again, the industry thought that this was a change that had been instituted to essentially strengthen creditors' rights when they petitioned.
Yes.
Another insolvency firm here put out a similar update in January 2021, essentially mirroring these law firms.
Yes.
So it was the industry's perception that this was a change. And now we move forward to this year, March 2021, and we have the curious case of the PopUp Globe Foundation Limited. And what this really highlighted was that this change didn't actually happen.
So let's take it back. So the PopUp Globe was, and most of you will remember, there was the PopUp Globe, and
it's
they
still
were doing,
there actually. It's like the actual building is structure is still there.
Now safely in the hands of a liquidator.
Yeah.
So the PopUp Globe was served by the Inland Revenue Department with a liquidation application.
Correct.
Notwithstanding all this, the shareholders of the PopUp Globe went and appointed their own liquidators. Anyway, so they appointed their own insolvency firm, or their own liquidators. The Commissioner of Inland Revenue pushed the issue and took it to court, and took it in front of an associate judge, and I guess my expectation would have been that the associate judge would have said, without the consent of the petitioning creditor, which is the Inland Revenue Department, that liquidator's appointment would have been invalid. But that's not what this associate judge did. So what did he do?
No, so the associate judge interpreted the section, and he put real emphasis on one word in that, and it was the word or. Now, we can look into the legal mechanics, but it's section 241AA of the Companies Act, which is part of the amendment that came through with the Insolvency Practitioners Regulation Act in September last year. And it included a new section, being the or, and being if the application is made under 241C, being a petition creditor claim, the creditor who filed the application consents to the appointment. Now, Associate Judge Bell, who was the judge in this case, saw it as being a dual pathway option, that you could still appoint within 10 working days, or if the applicant also consented. So there's essentially two pathways here that the judge...
The second part of that is completely redundant.
Correct.
And so... But the way that we read this section was that if the company had been served the liquidation application by a creditor, then the 10-day rule was gone. If they were served a liquidation application by somebody other than the creditor, and there are other options, the company can appoint itself, there could be a shareholder, there could be the Reserve Bank, all of these are options under the Companies Act. We had assumed that the 10-day rule still applied for that. But but that was not the case. But we also picked up some gossip.
We did, and just before we get onto that gossip,
everybody loves the gossip.
I just want to just talk about the sort of the reasoning behind this this decision was that now creditors can consent to a liquidator after the 10 working days.
Yes.
So there was a situation under the old rules where if you were outside the 10 working days, there was really no possibility for a shareholder to appoint, even with the consent of that petition creditor. But now what we're seeing is that there is this option here for there to be a consent of the parties. And I guess with regulation coming in, what this is telling us is that there will be no rogue operators. Essentially that because the standards have been lifted, we're not going to have, the minimum standards essentially being...
All the rogues have been excluded.
All the rogues are excluded now. So what that means is that the creditors should have confidence that there'll be no, friendly shareholder liquidator put in that will act against their interest, which I think is essentially what the purpose of this change was. So to some degree, it could be mitigated by that. But the gossip that we've heard around the traps is that there was some last minute prodding and poking to MB to essentially have this rule tweaked, and
yes.
that's resulted in this.
And that's what happened because in some of our other enterprises, particularly Tempest, we saw this as a very powerful tool because we saw this once we were able to issue a liquidation application on a debtor company, then the debtor company would be stuck with a liquidator that we had chosen. But that's not going to be the case. They're still going to get 10 days.
There is going to be still that time period. As long as this judgment is the precedent, which it currently is, there's nothing counter to it. That will be the position. And
our understanding is it's not going to be appealed.
Yes, correct. So we understand that there will be no appeal of this judgment, which is essentially pointing to the fact that a legislative change may be required. This is to be picked up further, which, given how long the insolvency regulation took to come into force, about 10 years from start to finish, it's very unlikely to see any further tweaks in this.
But having a look at the wording of the legislation, because you're very familiar with it, as am I, if it was appealed, what do you think the chances of appeal would be?
I don't think the chance of appeal would be very high, given that there was that tweak to the change and the fact there's an or. And I think the liquidators that were put into PopUp Globe were Ecovus KGA.
So the upshot of it is that there has been a lot of information in the last 6 months that if you received a liquidation application, you are unable to appoint your own liquidator, which means that people were receiving a statutory demand and then perhaps appointing too early. The rule currently as it stands...
But we were part of that, right? We were part of that information.
Yeah, we were guilty as everybody else. But the rule now is, it's not a very firm rule because it may well be challenged. But at the moment, the rule from the courts is that if you've been served the liquidation application, you have 10 working days. For the shareholders have 10 working days to appoint a liquidator. And the good thing here at Waterstone is that we have a liquidator.
We do. So if you have been served with a statutory demand or even a liquidation application, you need to act fast. So get in touch with us. Our information will be below, and have a chat if you have been served and you actually want to have some preliminary advice on what to do, who to appoint, all those good things.
Right. We'll see you next week. Thanks so much.
Cheers for watching.